Hello, everyone. Thank you for joining us. We're going to get started with the program. It's now 1 o'clock. First, some quick notes regarding today's program and reporting for continuing education. Today's program is entitled Design Firms and the Standard of Care. It has been approved for credit through the AIA as a live presentation. Here's the official course number for your reference purposes. We will record this webinar for educational streaming purposes, and we'll have the link on our website if you want to go back and watch it. But please be aware that credit is not offered for those who simply watch the recording. Today's live program, however, is indeed worth 0.5 hours of CE credit. And in terms of reporting CEs, after the webinar, by the end of today, you will receive a survey link. Victor policyholders who are also AIA members, we will report your completion of this program to the AIA, but please do provide us with your AIA number in the survey so that we can do so on your behalf. If you're not an AIA member, but a Victor policyholder, let us know in the survey whether you desire a certificate of participation and we'll send you one. And if you're not a Victor policyholder, no worries. You too will receive a survey link after the webinar, and if you'd like, we'll gladly send you a certificate of participation or report participation to the Institute if you're an AIA member. Note that there will be an administrative fee of $25, but again, just let us know your desire on whether or not you want proof of completion with the survey link, and we'll follow through accordingly. Whether or not you get a certificate or want us to report on your behalf, we would also like to get your feedback about this program and any other thoughts you may have about our risk management offerings. So with the administrative details out of the way, let's get started with the program. My name is Nahom Gabriel, and I am a risk consultant in the risk management department here at Victor Insurance. And today's program is, as you know, design firms and the standard of care. We'll discuss the design practice, the risks that you all have, the obligations that the law imposes on you, and sources of duty that are germane to your practice. We'll then do an explanation of what the standard of care means to you and how it relates to the coverage of your professional liability policy. We'll also discuss how you can defend yourself against allegations of negligence, what are some of the tools that your attorney will use, and what are some of the practice guides that can be used in order for you to help your attorney provide you with a robust defense. And hopefully this will help guide your practice and set you up for success. And then we'll conclude. And then, of course, I don't think we'll have time for questions, but if at any time you have questions, please feel free to use the chat feature or send in an email, and I'll be glad to respond via email as best as I can. Again, today's session is really intended to give you an introduction to this concept. We only have 30 minutes, but I think you'll be able to get some good information from it. So, generally speaking, in the US, the law is intended to protect the reasonable expectations of the parties. What I mean by this is that if I do something in my day-to-day life that causes harm to somebody, and I wasn't behaving reasonably as society would expect me to, then I'm going to be held responsible for the foreseeable costs of that wrongful conduct. So let's just say that I am driving my vehicle and I disregard a red light and cause an accident with a car that had the right-of-way in that intersection and cause some property damage and even some injuries to the driver of that vehicle. Then under these circumstances, as I've described them, I will be responsible for the cost of repairing that car damage, that property damage, and also making sure that the personal injury costs that the driver has suffered are compensated for. So I will most likely be held responsible for the hospital bills and so on. This is because the other party had a reasonable expectation that they would be able to cross the intersection without an accident because they were following the law of the land that said you can only cross when you have a green light. Notice, however, that the law doesn't expect me to be responsible for all of the costs that the other party may have suffered. If the individual I harmed in this accident, for example, had reason to go, had a business meeting, and because they had to deal with my wrongful conduct, missed that business meeting and subsequently lost the opportunity for a lucrative deal that would have set them up for life, the law is not going to require me to compensate them for that loss, even though they lost it due to my wrongful conduct. Why? Because that is not foreseeable. That is not something that I will be held responsible for. Similarly, in your design practice, be aware that even if you have wrongful conduct, as we will outline in a second, it doesn't mean that you will be responsible for all of the foreseeable costs that may be imposed on you. The law also recognizes that design practice is a complicated endeavor. You're not expected to make sure that the client doesn't have any adverse consequences. The law recognizes that there are trade-offs involved, that there are risks in any endeavor where construction is involved. Oftentimes, you're helping a client put into place a capital asset, and with that comes uncertainty and risks. And the law recognizes that there are trade-offs involved in the consulting services that you offer. The trade-offs oftentimes are in terms of money, time, and quality. You're often obligated to provide services according to the scope of services and what you and your client have agreed to. And for that promise of providing services, you're being compensated with money. And there's also a recognition that depending on the scope, you will have you will have certain responsibilities. So with that said, the law recognizes that and doesn't require that you remove all elements of risk from the client. So let's move on and talk about where do the sources of duty come in to you. As a firm or an individual practicing architecture, engineering, surveying, landscape architecture, oftentimes there are duties imposed on you by statutory law, right? You're often licensed to practice, and the deal that you have with the state, with the agency that says that you can practice in this particular state is that in exchange for your commitment that you will not endanger public health, safety, and welfare, and the fact that you are duly, you have the education and the experience to take on these responsibilities, the state will grant you a license. And that license means that only individuals such as yourselves are licensed to provide these types of services. These are not the types of services that anybody can provide currently anyway in the United States, based on the fact that it's a free enterprise system. It's a licensed profession. That means that you have certain obligations that you have undertaken. Your basic obligation is that you will not endanger public health, safety, and welfare. And even if you have it, even though you have a duty to your client, that doesn't mean that you can just disregard the concerns that the public has about public health, safety, and welfare and do everything that the client asks you to do. You have to balance that against your obligations to the public. In addition to that, of course, you have tort law. This is where we'll be talking about the standard of care that applies to your services. And beyond that, of course, there's contract law. This is private law that you enter into with your client, specifying exactly what it is that you all have promised to each other. You've promised to provide services, they're promising to pay you. That agreement will be enforced in a court of law if there is a dispute between you two, right? So these are generally the sources of duty that you all need to be aware of as you manage your practice. So how do we determine fault and liability in contract law and in tort law? Under tort laws, we'll talk about, that is really based on the standard of care, and we'll talk about what that means. Under contract law, you and your client, this is generally between two parties, are free to assume obligations. You can change or create rights and obligations as you see fit, and you even have the ability to exceed what would be considered your normal legal liability under tort law, as we'll talk about. And the courts will look at these four elements anytime there's an allegation that you're responsible for something. What is your duty? Did you as an engineer or an architect breach that duty? And if so, was there damages that the plaintiff, the person alleging that you caused them harm, is there a connection between that breach and the damages? In other words, did that breach cause the damages that the plaintiff is alleging? This is fundamentally what each and every allegation is going to have to prove. And so you need to be aware what your duties are. Did you breach that duty? And did that cause damages? And now this applies both for tort law and contract law. Tort law is based on the standard of care. And we'll talk in more detail about what that standard of care means. So negligence law under tort law is based on your failure to meet the standard of care that you owe to the plaintiff. In your world, we say the plaintiff, it could be, most often it's going to be your client. About 70% of all claims against design professionals such as you come from your clients, but it could be anybody else. And the allegation is that you fail to meet that standard of care. And if that failure to meet the standard of care, and we'll talk about how that's defined in a second, causes damages, then you will be held responsible for that. Now, in the United States, there are 50+ jurisdictions, all of that govern your obligations. It's very jurisdiction specific, but if you collate all of that law, it really comes down to this definition. And a lot of times you can see how your particular jurisdiction looks at the standard of care and negligence law by looking at jury instructions. Now, I pulled the jury instructions that the District of Columbia gives in allegations against professionals. And the jury instructions say a professional, it could be doctor, lawyer, architect, engineer, surveyor, is not negligent if he or she adheres to the standard of care in the field. You, meaning the jury, must decide whether the defendant was negligent by deciding whether the defendant failed to perform according to the professional standard of care. And this is what the jury has to determine. Did the defendant do what a reasonable and prudent professional in his or her field would have done under the circumstances? What this means is that ultimately you are expected to perform in the same way that another architect or engineer would have under the same circumstances. And that's what is meant by the standard of care. Now, obviously, this is not an easy thing to determine, especially for a lay juror. Because the plaintiff, and this is, remember, it's the plaintiff's responsibility. They must prove by a preponderance of the evidence what standard of skill and care do reasonably competent professionals follow when acting under the same or similar conditions. And then they determine that they must find that the defendant did not follow that standard of skill and care, and that there's proximate cause to the damages that the plaintiff has suffered. So as you can imagine, for a lay person who's been called into jury duty, this is not obvious. Whether or not an architect's performance on a particular project, as you can imagine, it can be fairly complex. Whether or not that it met the standard of care for that particular project type at that particular time is not obvious. So what the jury is going to rely on is the expert witness. And the plaintiff will have to engage the services of an expert witness to establish what the standard of care is. And not only do they have to engage the expert, but the expert has to be able to relate that standard of care applicable to the specific facts and circumstances. So what kind of project is it? What is expected? All of that is something that the expert would have to give an opinion on based on what they believe to be what is expected. Then they will provide an opinion regarding any deviation from the standard of care. That means that if it's the plaintiff's expert, obviously they're going to, in order to further the plaintiff's case, they're going to find most likely that indeed your services, you the architect, you the engineer, you the surveyor, do not meet that standard of care. And they will offer an opinion whether such deviation could have resulted in the harm the plaintiff suffered. So what we have is really a case of dueling expert testimony, because what your defense attorney is going to do is that offer up the opinion of an expert who will testify on your behalf after reviewing the services that you provided, after looking at the scope of services, that indeed you met the standard of care, that indeed you were not negligent. And really, it is these dueling expert witnesses that would go before a judge and jury to make the call as the case may be. The fact finders really rely on the expert witnesses to clarify the standard of care. You will not expect a state court judge or beyond that a jury to know the intricacies of what's involved in an architect, what an architect is supposed to do or what an engineer is supposed to do. That is the way our legal system is set up. The reality is that most cases that come against architects and engineers are settled. There may be some initial discovery to ascertain the facts, and that often helps the parties come to a decision about what makes sense about how to resolve a case. But over 97% of cases that are brought against design firms are settled. But you need to understand what the standards are so that you can plan your practice accordingly. And now, just briefly, let's take a look at how your professional liability policy talks about this, because this piece, this risk that you will be held negligent, is why you purchase your professional liability policy. If you look at the definition of wrongful act, which is what we say, we being CNA, says that they will provide you coverage for, means an act, error, or omission that causes liability in the performance of professional services for others by the insured, that is you. What that means is that CNA is saying, hey, we've issued you a policy, and if indeed the allegation is that you are liable due to your performance of professional services, we will be there subject to the policy, deductible being met, and all of the other conditions of the policy. We will be there to provide that coverage. What causes liability in the performance of professional services is your negligent performance of those professional services. So that is what your policy provides coverage for. So as you negotiate with your client, you know exactly how that risk is being handled. The reality is that, of course, the law doesn't say that your liability is limited to a certain extent. If the plaintiff, oftentimes the client, suffers harm and there are lots of damages, if it is indeed due to your negligence, then the liability is obviously unlimited. The reality is that firms such as yours live in a world of limited resources, and the practical limitation of your responsibility are essentially the limits of your professional liability policy. So God forbid something like that should happen, that's what would guide the settlement discussions. So your PL insurance really is a tool of the risk management process, and you need to understand that. You need to understand how these risks are handled. Obviously, it's there to protect your corporate assets and shareholder investment. The policy is there to shield those assets, and you're well aware of that. It also protects the professional because, as I alluded to at the beginning, these practice laws require that the individual be responsible for anything that they've signed and sealed. And if it doesn't happen often, and you happen to be working for a firm and you as an individual are named as a defendant, then as long as there's a current policy in place, that professional is indeed considered an insured under the definition of what an insured is in the policy. So it behooves you to know exactly that your firm does have an active policy in place as you're performing these services. It helps you manage your potential project risks, obviously, and it really does support your contractual commitments. Because as you're negotiating, even though this is not a program about contracts, most oftentimes the negotiation about your performance standards does revolve around that standard of care. To the extent that you can guide the discussion, your contractual commitment to that, then you know that you have a reasonable performance standard. But ultimately, as a design firm, as a design professional, it's up to you to manage the client's communications, expectations, and execute on the project, because the presence of a policy itself is not going to get you that. Now, there are things that the defense attorneys have that I want to briefly mention as to how, when you have an allegation of negligence, because there are defenses that are available to you that I think it would be good for you to at least be familiar with them. We don't want to go through a legal course, diving deep into what the toolkit is for defense attorneys, but I think some familiarity would be helpful. And I think 4 states or so, there still is a notion of contributory negligence, whereby if you as the defendant can say, hey, the plaintiff was also negligent to some degree, that means that the plaintiff cannot recover because there's some element of contributory negligence. Now, in its purest form, obviously, this can lead to some very harsh results. You can imagine somebody being injured where you are responsible for, let's say, 90%, but the person being injured is only responsible for some minor negligence, but because of that, they can't recover. That could lead to some pretty drastic results, barring recovery by sympathetic plaintiffs. So most states nowadays have moved away from that. And there is this notion of comparative negligence, whereby you are only responsible to the extent of your negligence. What this means is that you and your attorney will be able to say, hey, yes, we may be responsible for a portion of this, but hey, Mr. Owner, you failed to maintain the facility the way you're supposed to. So there is some negligence on your part that should lessen our responsibility, right? So those are the types of arguments that the client that your defense attorney may use as you come to a settlement. The other notion that you should be well aware of is the assumption of risk. If you know that a particular course of action is risky, but the client has been informed and they have agreed to it, think of an informed consent form that has been presented to the client and they've signed on to it, then they have assumed that risk. So even if indeed there is something that has happened, if you can show that the client did assume that risk, that helps to combat allegations of negligence. Again, these are some of the things that your defense attorney would use. Betterment is also an interesting concept. Let's say your drawings did not show that you put in a handrail, for example, that it doesn't show the details of a handrail, and that the code requires that a handrail be put in. What that means is that you are responsible for the additional costs that the client has to expend in order to put in the handrail at such late date during construction, but it doesn't mean that you owe the client the cost of a handrail itself. The client is expected to pay for that handrail. It doesn't necessarily mean that you get to front the entire cost of that handrail. So that's how these types of arguments would work. Obviously, there's time-based defenses. If the client, if it doesn't come to make the allegation in a timely manner, then they won't be able to recover against you. But from a practice standpoint, and this is how we're going to end this presentation, what can you do in your day-to-day practice to combat allegations of negligence? How can you help your attorney combat these allegations? And this really relates to your practice management issues that I think should be addressed and thought about. You need to focus specifically on the client and the project as you work with your client. Clients oftentimes want to know what is going on with their project. And if there's any issues that are going on, if you think deadlines aren't going to be met or expectations aren't going to be met, then it is up to you to proactively manage that process with the client. You want to be able to clarify vague requirements and refine onerous duties and responsibilities so that it is clear who's responsible for what. If, for example, you're moving through a design and you need to clarify what is expected, make sure that the client signs off on your solutions before you move on. Oftentimes that's required by contract, but even if it's not, make sure that everything is well spelled out and the client is indeed informed of what's going on. You need to create a record of your client decisions and authorizations. What did the client decide and how did they instruct you to proceed? Remember that when the claim comes in, you want to be able to have a project record that reflects what actually happened during the project. You don't want to be in a position of having to rely on the memory of you or former employees who may no longer be at the firm, who may not remember exactly why you proceeded in a particular direction. So you want to have a practice management system where you record your client decisions and authorizations, and also how you as a design professional came to recommend the particular solution. What kind of research did you do? What did you look at? What are the options you considered? What are the calculations you did to back up your particular recommendation? All of these things will help you establish conformance with the standard of care if indeed there is an allegation of negligence. And then finally, obviously, it's your quality control efforts. Refining your project management procedures to address client goals and expectations is essential because you can't have a cookie cutter approach to all of your projects. It needs to be tailored to what the client's goals and expectations are. Verifying your concept both internally and with your client and other appropriate stakeholders. The stakeholders could be things like the authority having jurisdiction, who may have to review this eventually, your subs, other consultants. Make sure that indeed everybody is on board with the direction that you're going in. And obviously reviewing your design efforts and deliverables for suitability and sound design practices. What that often means is that indeed you have to proactively, depending on the scale of the project, budget time for internal review, because that indeed is what it comes down to. Oftentimes what we see is that you have the technical competency, but you just did not have enough budget in there to do the appropriate review before releasing design for construction. So that is some of the things that we have seen in our, when we review claims files over the years. So this is really intended to provide you with a brief 30-minute synopsis of what the standard of care is, how it relates to the professional liability policy. I hope you found this useful. Please provide us with feedback when you get the link. I just want to end with a description of our uh, resources. We have the School of Risk Management for this for our policyholders, and of course, there's lots of resources here. There's webinars, publications that are intended to help guide your practice. We encourage you to set up an account and please take advantage of these resources that are available to you as a policyholder. And that brings me to the end of the program. Keep an eye out for that seminar, for that survey, and please provide us with feedback. We're especially interested to hear what you think of the new 30-minute format. Is this something that you find useful? Anything that you can provide to us in terms of feedback would be most welcome. And with that, that's the end of the presentation. I'll be responding to any questions that have come in via email. Thank you very much.